Hello, everybody. Phil Snyder, GunClassUtah.com. Hey, we are just going to finish up the laws of the Utah Concealed Firearms Permit course. So let's get started. State of Utah has established secured areas throughout the state. The secured areas will be correctional facilities, law enforcement buildings, mental health facilities, the state tax commission, certain areas, certain areas of higher education. So colleges can establish secured areas. Judicial councils can establish secured areas. So an airport is also a secured area. And I've covered the airports under the weapons laws video. And there was quite a bit of detail to that. So we're not going to discuss airports under this video, but we'll do the other ones. So any secured area it shall have a sign posted in a prominent location at the entrance to that secured areas where they want to keep weapons and explosives and ammunitions out of. If it doesn't have a sign posted, it's not a secured area. Now, mental health facilities, I usually don't see those, but at the state hospital, there are certain areas where I visited there during some training. Same as law enforcement buildings. A lot of law enforcement police departments, if you just go into the lobby, you don't see any signs there. It's not a secured area. So just keep that in mind, because if you go into a secured area and it is posted, and it can be up to a felony depending on your intention when you go in. If you enter a secured facility intentionally, knowingly bringing that prohibited item out, it can be a felony. And it could be as minor as a misdemeanor depending on whether you intentionally or knew or not. So just look for those signs and you should be okay. Other areas. It is against federal law to travel with a firearm on your person on Indian reservation land without permission from tribal leadership. This is not driving down the interstate through Cortez, Colorado, but let's say you get off the freeway and you get gas in your car and you're on the reservation, you cannot bring firearms into those buildings that's on Indian reservation land. So just be careful of that. Also, it is illegal to go onto any property that is owned or leased by the federal government. The post office is a federal building. Even if you leave the gun in the car and you're parked on their property, you're in violation of federal law. So if you want to go to the post office, you could park on the road right out in front of the post office, and you wouldn't need to worry about that. Also, federal parks. Let's use Yellowstone as an example. You can carry your concealed loaded firearm into a federal park subject to that state's laws while you're traveling through that park if you have a firearm permit. If you don't have a firearm permit, my understanding is that you cannot unless that state's law allows you to do that. Federal law also states that unless you are an FFL dealer engaged in firearms business and you're transporting firearms for that purpose, it is illegal to travel with a concealed loaded firearm. Now, the way we get around that is we have a concealed firearm permit and we are traveling through a state that has reciprocity. That is the exception to that. But federal law says if you don't have that permit, then that firearm, if it's going to be transported within the passenger area of your vehicle, it must be completely empty chamber, empty magazines, bullets, cartridges separately encased in the box. They're separate from the gun, and the box is locked. And locked glove boxes and locked consoles do not count as far as a lock container goes. It has to be an actual lock that it's secured in. Just remember, everybody, the only thing that the Utah concealed firearm permit allows you to do is to carry a concealed loaded firearm in your vehicle and in public places that are legal if you are in a state that has a reciprocity agreement with Utah. That's all it does. You still have to follow the state's laws. The use of force laws are going to be different as well. When you go to a concealed firearms class, they're going to talk about Utah use of force law. That's only in Utah. So another thing to keep in mind is that laws can change any given year. So it is your responsibility to keep up in the know with current laws. And I would take a refresher, or I would do a refresher on your own every year. The past 2 or 3 years, the Utah legislature has made significant changes to the laws, and you really got to stay up on that to avoid legal troubles. Uniform firearms laws, okay? Basically, this is your constitutional right in the state of Utah to keep and bear arms. One other thing, this says the Utah legislature has exclusive jurisdiction on firearms laws throughout the state. That is a good thing. Some states, like Oregon, each individual city and county can make their own firearms laws, which can really confuse things when you're going from one city to another. But in Utah, unless they otherwise designate it to somebody else, or unless it's otherwise authorized by law, the Utah legislature makes all those laws and has jurisdiction. So it makes it really easy because you can just go to the Utah legislature to look up all of these laws. So, as I said earlier, a concealed firearm permit just allows you to carry a concealed firearm in public and in your vehicle. However, under the Utah Constitution, there is no permit requirement to carry or possess or transport a firearm in your places of residence, your places of business, and in your vehicle or in somebody else's vehicle that you have permission to carry in. In those areas, there are no laws that govern possession of firearms, accessories, and ammunition. Constitutional carry for everybody that's over 21 years of age, and they're not restricted from owning or possessing a firearm. They can carry a concealed loaded firearm in public places and in their vehicles without having a permit to do so, with restricted areas, of course. Now, if you are 18 to 20 years old, you do not have constitutional carry. However, you can, if you are an 18 to 20-year-old, you can open carry. That means the gun is clearly visible. It's not covered by clothing. Clearly visible to somebody walking up on you. And it has to be statutorily unloaded. For example, if you've got a Glock or any other semi-automatic handgun, and you have the empty chamber and you have a full magazine in the gun, but it's not in the chamber, one has not been loaded, 18 to 20-year-olds can carry like that if it's open carry, and again, it's statutorily unloaded. Now, those 18 to 20-year-olds, when they get a firearm permit, now they can carry it concealed and loaded. The other advantage of having a permit is that, and this applies to both standard and provisionals, is that you can have loaded rifles and shotguns in the vehicle. So if you're hunting or something like that, then there would be an exception to that. We already talked about where you can and cannot carry. Just briefly, any secured facilities, churches and private residences that ban firearms, airports, mental health facilities, daycare. It used to be unlawful to carry in a daycare for provisionals, and now this year they're allowing those 18 to 20-year-olds with a provisional permit to do that carry into those areas. So I think that pretty much sums up the constitutional carry and the provisional carry for those 18 to 20-year-olds. Statute here just clarifies what the definition of a residence is. Okay, so we talked about there's no restrictions from carrying into those places of business that are under your control, or your vehicles, or your residences. So down here at the bottom, it also says that a place of residence can also include temporary residences or camps, so tents, travel trailers. You're out camping, you're renting an apartment or something like that. So anywhere where you are staying that is not your primary home, including hotel rooms, is also considered to be your residence, and there's no restrictions, as we discussed earlier. This law right here protects private property owners that allow firearms owners, people that like to conceal or open carry firearms onto private property. So a private property owner is not liable civilly or criminally for allowing somebody to carry a firearm onto their property, unless the property owner solicits, requests, commands, encourages, or intentionally aids the firearm possessor in discharging the firearm while on the property of the owner, or if they are acting for a purpose other than lawful self-defense under this section. Not alter the responsibilities of a tenant owes a landlord under the terms of this lease agreement entered in between the tenant and the landlord. Here we go. Firearms can be banned in public homeless shelters. So if there's a homeless shelter and somebody brings a gun into there, whether it's a permanent or a temporary facility, they can ban firearms into the facility by posting signs, posting notice of their intent to keep guns out, and the facility, the homeless shelter, has to provide a storage means for the firearm while that person is visiting in the shelter. So, for example, if somebody came into a homeless shelter and there was no firearms allowed in there, then the shelter would have to have some sort of a secure lockbox or something like that where they could store that while they were living in that shelter. The law also prohibits the shelter staff from collecting information about the firearm, such as taking photographs or recording serial numbers of the firearm. And the law allows the homeless shelter to turn in firearms if they've been abandoned for 7 days or longer under this statute. It's illegal to alter a serial number or mark on a handgun, and that would be a Class A misdemeanor. So don't remove serial numbers or other identifying marks. This law just reiterates that even if you're a concealed firearm permit holder, you have to obey any laws or rules that are established in these secured facilities. These are individuals who are exempt from certain weapons laws, okay? Basically, it's law enforcement and judges and prosecutors. Any U.S. Marshal, any federal official required to carry a firearm, any peace officer, any law enforcement official with a certificate, a judge with a certificate, a court commissioner with a certificate. This law right here protects certain activities with firearms. Okay, so it says a person may not establish, maintain, or enforce any policy or rule that has the effect of prohibiting individuals from transporting or storing a firearm in a motor vehicle on any property designated for motor vehicle parking if the individual, you, are legally permitted to transport, possess, purchase, receive, transfer, or store the firearm. The firearm must be locked securely in the motor vehicle or in a locked container attached to the motor vehicle while the motor vehicle is not occupied, and the firearm is not in plain view from the outside of the motor vehicle. Another little caveat under B, prohibit any individual from possessing any item in or on a motor vehicle on any property designated for motor vehicle parking if the effect of the rule or policy constitutes a substantial burden on their free exercise of religion. 2. A person may establish, maintain, or enforce a policy or rule that has the effect of placing limitations on or prohibiting an individual from transporting or storing a firearm in a motor vehicle on property the person has designated for motor vehicle parking if the person provides or there is otherwise available one of the following in a location that is reasonably proximate to the property the person has designated for motor vehicle parking. An alternative parking for an individual who desires to transport, possess, receive, transfer, or store a firearm in the individual's motor vehicle that, as long as it does not impose any additional cost on the individual and is in a location that is legal and safe for parking, or a secured and monitored storage location where the individual may securely store a firearm before proceeding with the vehicle into the secured parking area, or the person complies with subsection 34-45-107. Okay, I really like this law. It's been on the books for a while. Looks like they recently revised it. Okay. If we are in a state of an emergency, for example, we had COVID that was supposed to be an emergency for everybody. This law protects gun owners. It is unlawful for law enforcement to confiscate firearms in the event of a national disaster or an emergency. So, during a declared state of emergency or local emergency, neither the governor nor an agency of the governmental entity, so police departments and things like that, cannot confiscate those firearms, accessories, or ammunition. And if they do that, law enforcement can be disciplined. Law enforcement officers cannot be disciplined for refusal to carry out unlawful orders by superiors to do this. And if this happens to you, you can file a complaint with the Attorney General's office, and there can be fines for those governmental agencies that are violating your rights. So I really like that law. It's a good one. And lastly, the definition of an arrest is an actual restraint of the person arrested or submission to custody. The person shall not be subjected to any more restraint than is necessary for arrest and detention. Now, this year, the Utah legislature has basically removed the statute that talks about private person arrests, and they've replaced it with legislation that I've already talked about under the use of force video with the legal right to detain people for crimes. And so I'm not going to repeat that. You can watch that other video. But basically what this law is saying is that you should not use any more restraint than what is necessary to detain somebody temporarily. Okay, so let's say that you caught somebody breaking into your car and you told them to sit down on the curb and wait for the police to arrive, and they complied. You wouldn't need to tie them up or anything like I've heard some people doing, because that's all the force that's necessary. Well, I've decided to actually discuss this law because it is new this year. Okay, this used to say private person arrests, and they've used the word temporary detention made by private individuals. Apparently, the legislature didn't like the word citizen's arrest, so they've titled it a detention that you are allowed to do. What this law says is, if you witness another individual commit a crime or attempt to commit another public offense in your presence, or if you have reasonable cause to believe that a felony has occurred, under any of these two conditions, you can temporarily detain that other person. So the temporary detention is lawful only if you immediately notify law enforcement of the temporary detention and advise them of the situation, and the temporary detention only lasts until a law enforcement officer arrives. So if you're going to do that, which I advise, probably stay away from this altogether unless it's something that's a really big deal. I mean, first of all, if you can identify somebody, if you know who they are, you could identify them. There's really no need to detain if there's not a threat to public safety or something like that. This right here under B, it says that if you are aware that somebody else has called law enforcement, then there's not a requirement for you to immediately notify them yourself. These are protections that they've added in this year that they did not have previously. And it says that if you act in good faith on a lawful temporary detention, you're not liable for civil damages or penalties as long as as long as you were not grossly negligent, and you're not subject to criminal prosecution for an act or omission by the individual performing this temporary detention unless the private individual was criminally negligent. A private individual may use force while temporarily detaining another individual under this section. And I would also say, if it's feasible to do so, I would let them know of your intent, cause, and authority to do so. I would let them know, hey, I am a private citizen here making a temporary detention of you. I saw you breaking into my car. Something like that. Now, it wouldn't be feasible to give notice if giving them notice would get you hurt, or if they were fleeing the commission of a crime or something like that, or they're in the act of committing it or something to that effect. But otherwise, I think it's always a good idea. This concludes all of the laws for the Utah Concealed Firearms Permit Course 2025 refresher. Please like and share. Let's grow this channel if you enjoyed the material. Thanks for watching.